welcome to our 2022 seminar, which is part of seminar series that is run by the Linguistics and Translation and Interpreting group at UNSW Sydney. My name is Ludmila Stern. I'm a professor of interpreting and seminar convener, and I'm assisted by my colleague, Professor Sandra Hale. And I'm delighted to welcome a very numerous audience who are joining us tonight in Sydney. I know that you come from interstate and overseas, and you are in different time zones. So as I said, this seminar is recorded, and please, if you can, keep your microphones off. Now here at UNSW Sydney, we work on the land of Bedigal and Gadigal people of the Eora Nation. And I'm speaking tonight from my home, which is also on Gadigal land. And as a migrant to this country, even though I migrated many years ago, I'm grateful for the privilege to live, to have built my professional and personal life in this country. And I would like to acknowledge the traditional owners of this land, water and culture, and pay tribute to elders, past and present. And I also acknowledge and pay my respects to the Aboriginal and Torres Strait Islander people who are joining us today. And now to our seminar, Interpreting in War Crimes Trials. So, as I already said, I'm about to introduce our speaker, Dr. Alexandra Tomić, and please keep your microphones on mute at all times. Sorry for repeating myself. And after the presentation, which will take about 50 minutes, my colleague Sandra Hale will take the questions from the floor, and you will be able to write them in chat. So we would prefer if you could keep your questions in chat until the end of the presentation, just for us not to get distracted. And now allow me to introduce our speaker. So Dr. Alexandra Tomić has lived in several countries, in the former Yugoslavia, then Serbia, Switzerland, UK, the Netherlands, and now she lives in Belgium. She has a degree, a BA in French language and in literature, and in English language and literature from the University of Belgrade. More recently, she completed a master's in military studies with the American Military University, and she now holds a PhD in history from Leiden University, the Institute for History, and that goes back to last year, 2021. So congratulations, Alex, on a very new PhD. Throughout the years, Alex held many positions. Some of them were freelance translator and interpreter. And between 1994 and 2003, Alex was employed at the International Criminal Tribunal for the former Yugoslavia in The Hague. And that's where she worked as a translator, a field interpreter on missions, and then in booth as a court interpreter. And she works between her A languages, Bosnian, Croatian, Serbian, the so-called BCS, and her C language, French, into English, which is her B language. And that was at the Yugoslav Tribunal. That's where I first met Alex in year 2000. So it's over 20 years now. Now, in 2003, at the time of the creation of the Permanent International Criminal Court, the ICC, Alex was recruited to the position of a Chief of Language Services. And while at ICC, Alex set up the language services of the court, and she managed them until late 2020. While she was there, she organized testing, recruitment, and training of interpreters in European and African languages. So Alex, since then, has been working as an external lecturer at her alma mater in Belgrade since 2017, teaching courses as part of the Masters in Conference Interpreting and Translation. As I said before, she is going to present from her home in Brussels, and she's currently an independent researcher. Alex, I owe you a lot that has to do with my own research, because you facilitated my access and my research at the Yugoslav Tribunal and also at the ICC. When I first went to the International Tribunal for the former Yugoslavia, I was struck by the difference in the ways interpreting was practiced at an international tribunal. That was in such a stark contrast compared to Australian domestic courts, even in cases of international resonance, such as the Australian war crimes prosecutions in the 1990s. And so I'm delighted, Alex, that we have you as a speaker today to share your experience. So as I said, Alex will speak for about 50 minutes or so, followed by a Q&A moderated by Professor Hale. And I will be sharing Alex's slides. So over to you, Alex, and tell me when you are ready for me to share the slides.
Thank you, Ludmila, and thank you, Sandra. Thank you for the welcome. Good evening, everyone. It's a good morning from Brussels. I'm very happy to be here. Since I left the International Criminal Court, I've been very happy to accept invitations to present in different universities. And thanks to the wonder of Zoom, which works most of the time, I have been able to be in so many different places. And now on the other side of the world from me. So wonderful to see so many of you. So Ludmila, we can start. I'm going to start very quickly. This is my PowerPoint presentation is not gimmicky at all. This is just so that you see what I'm talking about. So we can start immediately to remind ourselves. Next slide, please, Ludmila, on how did it all start? Because when we talk about war crimes trials, or rather when we talk about conference interpretation, we forget that it really all started with the war crimes trials. So it started, but we can go on the next slide, sorry. Yes, so basically what we have, the origins of I'm sure you've done this, many of you know this already, but the very first, all conference interpreting is linked to war, as it were. The very first conference that had interpretation that was mostly in consecutive and shishutars was the Versailles Peace Conference. So that was obviously necessary because so many countries came to discuss the peace treaty. And at the same time, we had the first simultaneous, which was really more like side translation, because the delegates at the League of Nations, at the International Labour Organization, also in the same years, 1919 and 1920, as at the Versailles Conference, actually they did have kind of booths, but what happened is that they did not do real simultaneous interpretation, but they read pre-prepared translated speeches. The very first school for interpretation and translation came as late as 1941 in Geneva. So the very first simultaneous experience was the Nuremberg trials. So next slide, please, Ludmila. And those trials, just to remind you, I'm sure you know, these were the main trials, and of course there were many more later. But they were to do with the Second World War, which, just to remind, started in 1st September 1939 and lasted until May 1945 in Europe. I'm talking about the war in Europe. In Asia, it lasted until August. So next slide, please, Ludmila. So this is how many trials were held. Many 13-minute tribunal trials were tried, 200 Nazi leaders. But the most important thing, and why this is so important, is that legally, this gave important basic documents that will be used since that time, from that time onwards, and will, on the basis of which many more documents in international criminal law will be developed. And this is obviously the UN Genocide Convention, the Universal Declaration of Human Rights, and the Geneva Convention on the Laws and Customs of War. So next slide, please. So this is now we come to what we're talking about. These were the first interpreters at the Nuremberg trials. I'm so sorry, I seem to have sent you the wrong slide, the wrong PowerPoint presentation, Ludmila. Oh dear. Okay, I just see that it is different. Never mind. All right. Basically, that was this, as you can see, these are not really booths, or rather they are, but they were not booths as we know them today. The interpreters came from all walks of life. Many of them were refugees. Some of them had worked as military interpreters. Some of them have worked as intelligence officers, and so that was a motley crew. But what was important is that it gave birth to simultaneous interpretation, because it was really proven that it could be done. So next slide, please, Ludmila. So we had the languages that were used at Nuremberg were English, French, Russian, and German, and transcripts that were done transcripts were not necessarily transcripts. There were some of them were retranslations of what was said from the original. They are now kept in the Nuremberg archive at the International Court of Justice in The Hague, and this has been the case since 1950. So next slide, please, Ludmila. So this is what we're talking about the next conflict, which gave us more. This is the more war crimes trials. I'm not talking about the Tokyo war crimes trials, because that's another topic. So this was the first conflict in Europe since the Second World War, and the human cost was enormous. And the UN Security Council set up at the same time the ICTY, which is International Criminal Tribunal for the Former Yugoslavia, and ICTR, which was the International Criminal Tribunal for Rwanda. So next slide, please, Ludmila. This was the situation. This was the Socialist Federal Republic of Yugoslavia in 1991. This is what it looked like. So this area in green. And on the next slide, we can see that how it broke up. And these were the different entities that exist today. Next slide, please. This is what the tribunal looked like. It was located in The Hague because at the very early on, already at the end of the 19th century, beginning of the 20th century, the Hague became the city of international justice. It just evolved that way since from the times of the Carnegie Foundation that set up its peace palace there, and from then on, many courts and tribunals have set up their home in The Hague. So this is what the simultaneous interpretation, sorry, the courtroom looked like. This is a view from the courtroom in the ICTY. As you can see, there is a screen where you can see the participants, and there you can see the console. This you only see obviously one half of the booth. On the other side, you have again another screen. Usually, what we would do is that we would look on one screen. We would see the the speaker, and on the other screen, there would be a transcript. I'm going to talk about the transcript in a minute. So next slide, please. These were the languages. So English, French, these were the working languages of the ICTY, and as Ludmila mentioned, Bosnian, Croatian, Serbian, which we shortened to BCS. Why did we use this long form? Because the language formerly known as Serbo-Croat could not, for political reasons and for many other reasons, could not stay as one language. It was decided to separate, and there were no separate booths for that language, or rather for those languages, but in fact they are not languages, they're really dialects, but we decided to put them in one. And however, in translation, it was a different issue, because when we would send to Croatian authorities, to Serbian, we would make sure that they complied with the requirements of the relevant language. We occasionally also had Albanian and Macedonian. I have to stress here that Albanian wasn't Albanian from Albania, but it was Albanian from Kosovo, which caused its other issues, because there are also dialectical differences. Occasionally, we also had Russian and Arabic. There were other languages too, and they were to do with the witnesses who appeared at trial. Okay, next slide, please. I'm sorry I'm talking so fast, because I'm trying to get to the crux of the matter. So, because I started working there in 1984, and this is when the tribunal was set up. So how did it all work? Well, first of all, there were experienced conference interpreters who joined the tribunal, and they were mostly, I would have to say, they mostly came from Serbia, some from Croatia, and they had worked on high-level meetings before the war in the former Yugoslavia. And they were trained, they had a lot of experience, but they had a lot of experience in conference interpreting. And very soon it became quite obvious that conference interpreting, as we know it, which is that when you will strive for some kind of 75–80% of the message to be transmitted, in a sense that you would get rid of all of the little words that would not be necessary for the transmission of the message. Because this was to do with witness testimony more than anything, it soon became clear this could not be just a conference interpreting in war crimes trials. So the then chief of the service, who was an experienced conference interpreter, also realized that. So there was adaptation. The first trial started in 1996, so there was time to work out what was necessary. And the main difference is, as many of you will know, if you have read Professor Stern's articles, is that you interpret everything. So if you have a witness saying, answering the question, no, 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 repeating the word no, the interpreter cannot just interpret that as no. The interpreter actually has to repeat that word no all those times as the witness did, because that shows the vehement denial, obviously, of the question. Now, I worked as a translator, as a field interpreter to begin with, so that facilitated, because I hadn't been trained as a simultaneous interpreter before. And this is what very soon that I realized that, in fact, if you knew everything about the tribunal, if you knew the procedure, the investigations, how everything worked, that if you were able to interpret simultaneously, then it could be done with a in-house training. And in-house training that we did started first with shadowing highly experienced interpreters, which is what I did. First of all, we had a training which lasted about 6 weeks. Then I was shadowing experienced interpreters, so I was the third in the booth, listening, making notes and so on. And then I was thrown in it at the deep end, first with what I would say easier interpretations. What are easier interpretations in war crimes trials? Let me first tell you about the challenges. Next slide, please. So what were the challenges? First of all, we also had interpreters who came from elsewhere, who actually had, because we had 3 booths, BCS, we had English, and we had French. So if you had a BCS booth, everything that was said in English and French would be interpreted into Bosnian, Croatian, Serbian. So that obviously had to be done by the people from ex-Yugoslavia who were experienced interpreters, because it was the the accused, the counsel, his counsel, who needed to hear it, or obviously the witnesses, if the witnesses were from speaking BCS. Now, then you had the French booth, which was interpreting both from BCS and from English. However, we couldn't find enough in the French interpreters who had BCS. So what happened is that they were taking it on a relay from the English booth, which was always staffed by interpreters who were interpreting into English, and they were usually interpreting into B language, that is English, because again, there were not enough native English speakers who had BCS, and that's how I came to interpret into my B language. One word of caution. What happened to me really is that after I left my home in Belgrade in 1988, I went to live in England, and I completely stopped reading in Serbo-Croat then, and later in BCS. What I was reading were newspaper articles. I was not reading books. I had completely immersed myself in English. So English became my strong B language. But what had happened is that I'm sure you all, many of you know, maybe some students are not so sure, is that if you're a multilingual, you drop one language from your reading and your interpretation is going to suffer. And that's exactly what happened to me. So originally I was actually tested for interpreting into BCS, since I was a BCS native speaker, and I was terrible. The words were not coming to me. I couldn't remember because reading makes you a better interpreter. So I'm closing the bracket here, because this is what I always want to tell everybody: never stop reading in all your languages. So the problem for people who were not from the former Yugoslavia was that they didn't know enough about the conflict. So they actually had to get up to speed on the history, on the locations, on the names. That was hard for them. For all of us who were from the former Yugoslavia, and that's the majority of us, dealing with the subject matter was extremely emotional. Just to give you one example, and that came from my experience as a translator, is that I happened to have been translating into English a bunch of witness statements, and everything that was happening in Croatia. So not where I come from, as I come from Serbia. However, all of the people in that little village in Croatia that had suffered terrible massacres and killings, they all had this, pardon me, they all had the same last name as me. They all had the last name of Tomić. So as I was translating this into English, it is a very strange experience to suddenly think, I don't know these people, but I know them. I mean, I feel an affinity. And this is when you feel, this is crazy. You know, it's kind of, I think it dawned on me, although it's silly, it's just a same last name. But of course, you realize you are all the same. And suddenly these people were in fear of their lives, and so many of them lost them. So that was really hard. It was difficult for people from Bosnia who had escaped shelling to then come to the tribunal and then deal with the same, with witnesses testifying. That was very difficult, and we didn't get any psychological support until many years later. Now, for the conference interpreters, I already mentioned they needed to adapt their interpreting technique, and especially not to embellish, not to make somebody, this was quite important, not to make somebody, a witness, sound more educated than they are, or the other way around. So you should really pitch your register at the right level, so that that was, some of them found it hard, especially those experienced diplomatic interpreters who had covered many conferences in the former Yugoslavia and all over the world. And they had fantastic diction, they had amazing intonation. But when they were speaking as if they were speaking that a minister was speaking, while we had a simple witness who was giving testimony. So that was something that some of them didn't quite get it, but it worked. And of course, the difficulty was to learn simultaneous. I have personally always found that consecutive was much harder than simultaneous. Simultaneous, you're behind the glass. And if you have that setting in your brain where you can transmit the message, it takes some training, but it's I didn't find it terribly hard. And getting back to the consecutive afterwards, I found much harder. Learning about legal concepts was so difficult because, among other things, because I'm not a lawyer and there are no common law terms in Bosnian, Croatian, Serbian. So, because former Yugoslavia is civil law. So obviously a lot of things like, they're completely different systems. And of course, anything from what we've all seen in normally US series, courtroom drama, I object. It's just we had to find the equivalents in BCS. And a legal argument caused a lot of trouble, and it took us. I was very happy that very early on I was shadowing an excellent interpreter who later became head of interpretation at the ICTY, and she told me very early on. She said, "There is nothing as difficult as legal argument." And that is because you really have to prepare. You have to have the documents. You have to know what is it that they're arguing about. You cannot just parrot what's being said. You cannot just mirror the arguments. You actually have to understand it. And I can also tell you that the scariest thing that can happen to an interpreter in this situation is that you prepare, you think there's going to be a witness testimony. You arrive at the court plenty of time before. You have your coffee, you go into the booth, and both you and your colleague are prepared for the witness testimony. You know who the witness is, you read the statement, you're prepared, you looked everything up, and now you just have to make sure that you do it all properly. And then first there is a delay, and this has happened on a number of occasions to all of the interpreters, and suddenly there is the hearing starts, and then the presiding judge says, all right, point of order, we would like to state that although we were going to hear Mr. So-and-so, before we start with the witness testimony, I have to say that Chambers received an appeal late last night that the testimony shouldn't be heard. And although I don't like this, I think we should hear the legal argument. And this is when you start to be absolutely horrified, because you realize nobody from Chambers or from the prosecutors or from the defense has sent you anything about this legal argument, who and why are objecting to this witness, what's happening. Sometimes this happens, and in a real court, I should say, in a monolingual court, that's not a problem, because there are no auxiliary services of this type. But here, everything depends on this. And suddenly you realize, oh no, I actually have to know what's going on. And so legal argument, you cannot improvise it. So that was that is the point I really wanted to make. Another thing you cannot improvise is anything specialized, such as forensics and ballistics. So forensics, this is things to do, for instance, with medical reports, postmortems, and so on. We had any number of experts testifying. Again, you need to understand a lot of things. You can't just know the terminology without knowing what's what. Ballistics, again, what is the velocity of a bullet? What is the trajectory of the bullet? All of the terms to do with piercing, fragmentation. You need to know a lot of things, and all of those things are kind of, I would say, weigh on your brain, and you feel, oh, am I ever going to be able to go back to being a normal person who doesn't have all these terms knocking around in her head after finishing the hearing. So real-time transcripts, that's the next challenge. So shall we go on to the next slide? Sorry, Ludmila, I have kept you waiting. Yes. So how does real-time transcript affect delivery and reception of interpretation? What is a real-time transcript? So imagine that you are interpreting in the courtroom. We saw the booth, and there is another booth, and they are court reporters, and the court reporters are typing up what is being said. It's a special software which does shorthand, and everything that they type comes out in real time on everybody's screens. So practically, that means that this was in the ICTY, the real-time transcript was only in English. That means that we would see the transcript. So as I am speaking, interpreting into English, I would see all my notes, all of the, everything that I'm saying would be coming out. So that's, I would not watch that as I'm interpreting, because that's extremely distracting. However, if, for instance, and the counsel asks a question in English, and it's a very long and difficult question, it would help me, for instance, if I'm interpreting into French, to actually see how the question began. Did the question begin with "did you" or "have you" or so on, just so that I know how to formulate the question in French. So for interpreters, this was the good side. The bad side for court reporters is that they had to get things right, because sometimes they would get things wrong, obviously, and the final transcript is finalized later. There are editors who are working on it throughout the hearing. But I think the most difficult thing was the courtroom users. They got used to looking at the screen. Over the years, they more looked at the screen and less looked at listened and looked at the interpreters. So that was something that one had to adapt to. The hardest thing is the legal status of transcript. In Nuremberg, that never came into the question. The transcript that we have now at the ICJ, this is now something for posterity. But the transcripts that you can actually go onto the ICTY site and see the transcripts from all of the trials, they actually have a legal status. So if there is an error of interpretation, transcript errors are always caught, interpretation errors are harder. So if there is an objection to the veracity of the transcript, then they have to be corrected. That means everything is kept, all the recording, and then interpreters would have to listen again to make sure. So that is about that. If there are any questions about it, I'll answer them, because I want to push on, because I see that we are about halfway or something. So right. So what is specific? I would say that preparation has to be done more than preparation that you would do for normal conference interpreting, because you have to also anticipate what can happen. The worst thing for an interpreter is to be surprised. And later on, when I became a manager at the ICC, International Criminal Court, I kept saying to all the judges and to the council, please do not surprise us. That also works for translators. No translator wants to be surprised by saying, oh, by the way, we need these 50,000 words for tomorrow. So this is a challenge for everyone who works in language services, is that the users, the customers usually don't see this as a big deal. Well, of course, there is a lot of preparation that has to go on behind the scenes. One of the things that is also very different is that there is to do with interaction. Speaking about the transcript, is that one thing I forgot to say is that before, one thing that we had to do because of the transcript is that whenever there was a question, every time whoever spoke in the hearing, everything had to be prefaced to identify the speaker. So if I'm interpreting from a French-speaking judge, I would have to then say presiding judge, and then say. So it literally takes away seconds from your interpretation, because you have to preface it. Otherwise, the transcriber would have no idea who is speaking. So, or if there was a questioning in court, it would have to be done question, answer, and so on. Interaction with judges. Now, in a transcript, you don't know what the actual speed of delivery is. So you have no idea. If you see a transcript and you see that it's a mess, that there are words missing and so on, or you don't know whether is it an idiotic interpreter or is it what's happening. And that's why very important that interpreters had to intervene. So interpreters had to say, interpreters request the council to slow down for the transcript, or please slow down for the transcript. So this is something that would have to be done. The court reporters would do the same. They would actually have a big banner sometimes appearing on the screens, because everybody was looking at screens. They would say, that there would be when slow down for the transcript. They also experimented with I'm trying to say, did we? Yes, I think we did experiment with the lights, as they did in Nuremberg. But it seems to be a very difficult thing. If you read something, if counsel are reading, it's usually a disaster, because they can't control the pace. And that was very difficult. Sometimes the interaction with judges was very strange, in a sense that the judge would there was an occasion during a hearing. Whoever is unmuted, please mute. Thank you. So the judge, there was a hearing, and it was to do with the word that kept coming up was the word terror, and the judge wanted the interpreters to define terror. So what we did was to actually get a Oxford English Dictionary and read out the terror definition. It was very difficult to deal sometimes with counsel criticism because there were counsel that would say things like, that's not what I said at all, and so on. And sometimes looking at the transcript, which wasn't quite correct, or sometimes misunderstanding what had been said. Occasionally, some counsel who thought they understood all three languages and therefore followed all three languages would also. So this is obviously hard. And of course, there are interpreter errors. I mean, whoever is an interpreter knows that this is something that happens. So we benefited as interpreters from having good relationship with the judges, good relationship with the counsel, also with every case manager who would send us preparatory material and so on. Now, secondary trauma, on the other hand, that is something that's really specific to the war crimes trials. What is secondary trauma? That is that you are traumatized not by directly experiencing a traumatic event, but by reading about it or interpreting it, translating it. And I think that this is known as the frontline staff, such as, well, frontline in a sense that we were there on listening or interpreting, being the voices of the people who were hurt or lost their family members in the conflict. So next slide, please, Ludmila. Right. This I wanted to show you. This is from a pictorial dictionary, and this is from a Srebrenica trial. Srebrenica is one of the, well, it's the site of the mass killing of about 8,000 Bosnian men and boys in July 1985. This mass murder occurred, carried out by Bosnian Serb troops, and after there were investigations on what had happened, some of the bodies were exhumated and then carried over to other sites. So it's probably until now the worst thing that had happened. This has happened in Europe since the war, Second World War. Now, what was necessary is that there were very many different types of machines that were used for this exhumation by the forces, by the Bosnian Serb forces, to move the bodies so they would not be found. And it was extremely important to be able to identify them. So we had different witnesses coming to testify to what they had seen. So that's why we had to know exactly everything about the machines. And this is what the kind of detail you have to get into. All right, next slide, please. This is from the book on translating evidence and interpreting testimony at the War Crimes Tribunal by Elias Bursac. And this is one of the takeaways for an interpreter. So this is, as an interpreter, you interpret everything said in the courtroom, including things you would never have the courage to say out loud. Sometimes you have to curse, be aggressive, direct insults at the judge or the chief prosecutor. You always feel awkward. The only way to cope is to numb your senses, focus on your job, interpreting. Obviously, as you can imagine, this leaves some consequences for your mental health, which is why looking after yourself is necessary. All right, we're going on to the next court. Sorry, this is just to finalize. The ICTY Language Services received the 2017 Hieronymus Prize, officially closed at the end of that year. And now there are still some residual matters that are being resolved by the International Residual Mechanism for Criminal Tribunals. It's a bit of a mouthful, and they are still working in the same building that you saw the picture of. All right, so next, here we are. This is a different building, different institution, also in The Hague, International Criminal Court. Next one, please. So it became operational in 2004. At the moment, it has over 900 staff members from approximately 100 states, 6 official languages, but only 2 working languages are used, French and English. However, case-related languages, so-called situation languages, exceed 10, and that's just in the courtroom. When we're talking about all the languages used, that exceeds probably about 30, if not more. So next one. The ICC, I'm going to go through this very quickly, is, well, does it have a global reach? It's supposed to be the world court. Well, it has country offices because it's dealing with different situation countries, as we call them. So in the DRC, in Uganda, in Central African Republic, of CAR, as we call it, Côte d'Ivoire, Ivory Coast, in Abidjan, and then in Georgia and in Mali. All right, next slide, please, Ludmila. At the moment, very quickly, there are 30 cases before the court. There are 18 ICC judges, issued 35 arrest warrants, 13 people remain large, and so on. This is not really important. This is just to give you an idea. This is very little. This is supposed to be a world court, and when you compare it to the ICTY numbers, you can do that obviously by looking at the website. It was obviously the ICC is only sort of just started in a way, only been operational for less than 20 years. But this is it's very difficult to operate, and things to do with bringing people to justice is to do with cooperation from the states. The ICC does not have a police, it does not have an army. Was that the case with ICTY? Well, yes and no, because ICTY had the NATO forces that regularly brought in the accused. All right, next slide, please. Now, languages. So languages of lesser diffusion, as we call them, the LLDS. What does that mean? That means that languages, at first the silly names were given, like exotic languages. Well, no language is exotic where it is, right? So we don't want to use that word. We don't want to use rare languages because they're not rare. Where they are, they're not rare. They may be rare in Europe, but that's a kind of a very Eurocentric way of looking at it. So this is the correct term. It's specific in a sense that they are languages where they are, but somewhere else there are less of them. So we started with the Swahili Congolese variant. These were for the DRC cases, and the Swahili Standard for the Kenya cases. Acholi is the language of Northern Uganda, which was used in a case, and Lingala was also used in several cases. Sango, language of the Central African Republic, was used in the Central African Republic cases. Kenya, Rwanda in the DRC case. One of the languages of Côte d'Ivoire was Jula, and Zagawa was used in the Darfur case, and Arabic in many different cases. So this, I'm just giving you a taste. What is so specific? We can go on to the next slide, please. is that because these languages, a lot of these languages were not taught in interpretation schools, there was no way that we could just look at the schools and bring in people and then train them a little bit about the court. No, we did consider in 2004, I joined there in 2003, and the first thing was how we're going to train the necessary interpreters for different cases. And so we decided what we had to do first is to train the trainers. And so some interpreters went to trainers courses, and we put together a curriculum for in-house training. How long did that last? Well, it lasted 6 to 8, sometimes 10 months, depending on the time we had. And how did we do this? Well, we tested people for aptitude, which was extremely important to make sure that people had the right attitude, the right knowledge, the right skill. Often, these people were already lawyers or had completed a law degree, and they had a very good second language. So all of the trainees were very, very talented, and we were extremely lucky to have them, to find them. And one of our trainers came up with after a lot of discussions and researches, one of our trainers came up with the slogan, "Context is everything." And the idea again was that if you learn everything to do with the court, the procedures, the investigations, what is the expertise required what are the locations, what are the names, by that you acquire the necessary knowledge and you can learn the skills, but then you don't have to worry about the locations, the history of the place, the geography. And that's how this worked. Now, the additional challenge in this is that all of the languages of lesser diffusion interpreters had to have a very good retour. What does that mean? That means that their second language, so English or French, had to be extremely good, because they would be interpreting in a language with both their A language and their B language, and another booth, so French or English, would have to be taking on relay. So obviously that put an additional pressure because of the transcript again, because transcript has a legal status and can be appealed against, and obviously we have to make sure that what's been said in the courtroom is exactly what has been interpreted, and that the two transcripts correspond, which sometimes is very difficult, partly because French is so much longer than English, and also because there are false friends, and sometimes counsel don't know that, so they will object where there is no need to object. So next slide, please. Again, challenges. I will start from the last one. So preparation. Again, preparation had to be thorough. Again, you had the same challenges in terms of witness testimony, and then you had to know everything that could happen. You had to know the procedure. One other thing to add: what was different at the ICC compared to the ICTY and the ICTR is that all of the common law terms were no longer used in the ICC, because they have decided to really make it not a hybrid tribunal, which would have both common law and civil law, but they were trying not to use a common law terminology, which of course sometimes gave way to even more complications. So for instance, in the ICC, the word indictment was not used. So there were charges. So these kind of, or for instance, you do not you're gonna do a questioning of the witness, but there's no cross-examination. But of course, you have to call it something. So it was examination by the opposing counsel. So sometimes these things fell by the wayside, and still the common law terminology was used. But that just shows how difficult it is to reinvent something when already something exists. Needless to say, the actual jurisprudence, so the case law, of course, was used from all of the international courts and tribunals prior, including other courts and tribunals, which meant that the terminology had to enter into the courtroom. What was another difficulty? Accents. So it was not a problem for people who came from the area to understand the accents, but sometimes there were really specific accents and specific type of using the accent. So one of my favorite examples is that there was a accused who was testifying. Could you please mute whoever is unmuted? Thank you. So that there was an accused who was testifying, and to his detriment, but he kept using in French the word espérer, which means hope, and really it really just means hope. Espérer is I don't know any other way to use that. Well, hope is the translation of espérer. However, it was extremely strange how he responded. So, for instance, there was a specific question. Did you go there? Was the question put to him, and he answered, "J'espère." I hope so. So we were all confused, as was thankfully the bench, and as was his counsel, and said, "What do you mean?" And then by questioning him, it turned out he was using the word espérer, hope, in the meaning of think. So in fact, French was his third language. And he wanted to testify in French in order to impress the judges or something, or he didn't trust the interpretation. So anyway, that I find is something very special. So it's not just accents that were difficult, but also the specific use of the language. And it's always useful. And that was why it was important that the judges and the counsel would trust the interpreters, because then they could focus on what was illogical in the testimony itself, because then they can figure out, oh, it's not the wrong interpretation. It is actually something in the original, which has to be explored further. As far as accents are concerned, some of the interpreters who interpreted French and English, and sometimes had difficulty in either French and English to hear the accents from different African countries that we were dealing with, they had to listen to the radios from those localities in order to be able to get used to it. A lot of them got much better with time. Much easier to look at when the interpreters started collecting these big case files on each case, so that all location specificities, the names of the places would be known. So you really have to understand what you're dealing with. Again, you cannot just be parachuted in the booth and be brilliant, because it's just not possible. Scrutiny at the ICC is extremely high. I would say that the level of lawyers looking at the counsel, looking at the transcript, correcting everything that's being said, even little details, even if the if the adjective is coming at another place, is extremely stressful for interpreters. And of course, really last but not least, trauma is something that that is extremely difficult to deal with, because not just for the people who come from those areas, but also for anybody, because it is all about people just like themselves, like everybody is like everybody else, and listening to somebody else's who has suffered in the past is brings it closer to how fragile human life is. And I think that is something that we can all sympathize with. Next slide, please, Ludmila. This time it was even harder, or it is even harder, I shouldn't speak in past tense, for interpreters, because real-time transcripts are in both English and in French. So that means that everybody was looking and comparing and complaining. So this is again very, very stressful for the interpreters. There are contentious interpretations in this council scrutiny, of course, and there is a whole long procedure of transcript correction, whereby whoever is contesting the transcript would then send a request, and then it would have to be listened to, which is very time consuming. And then it would turn out that it was, yes, well, one adjective was forgotten or something. Occasionally there would be some real mistake to be corrected, done by interpreters. But when you think about how long a trial is and how many witnesses appear, by looking at the transcript, and if you're following the trial, of course you're going to figure out that something is wrong. And it's much, much better, and this is what interpreters always insist on, is to say, correct ask the question again in real time in the court. Don't come afterwards saying this was wrong. Ask the witness himself or herself if something was wrong. So that is something that it's an ongoing battle. Secondary trauma I already mentioned. We can go on the next slide. So this is yes, it's okay. Thanks, Ludmila. So this is just to give you an idea. This is what a court reporter's booth looks like. So they are looking, they are listening, and they're typing, and what they're doing there is coming out onto everybody's screen. So this is also a hard work, often unappreciated, and we can never underestimate how important it is to have a good relationship between court reporters and court interpreters in war crimes trials, because it's hard for both of them. And of course, if they prepare together and work together, it's much easier for everybody. Last slide. This is from a paper that's written by Lise Zweigart, who has also done research at the ICC. And this is one of the interviewed interpreters. What I'm proud to say is that I know we have given a voice to the voiceless, and I think that's worth something. The witnesses who have come can at least say that they have spoken. And again, if you go to the ICC website, you will be able to see, look at some of the videos and look at the look at what the work of the ICC is. It is much more ambitious and much more difficult than the work of any other court that I can think of. And the first nearly 20 years have been hard enough, but I'm sure that the world can see now that you cannot have a world without peace, and you cannot have peace without justice, and you cannot have international justice without interpreters. So that concludes my, we can go forward. Thanks, Ludmila. That concludes my talk. I think I have kept it to 50 minutes, although I apologize that it's been occasionally very, very fast. So it's not a good interpreting, not a good interpreting rhythm.
Thank you, Alex, for that.
Thank you very much. Sandra, just before you move to the Q&A, Alex, if I may comment, there was another very important activity that you introduced as part of training and preparation of interpreters at the ICC, and it is the terminology unit that developed glossaries, because the so-called situation languages simply did not have the same richness they clearly don't have the same history of the legal system. So do you want to spend another couple of minutes just explaining what they did? I think it was extremely important.
Yes, it was. And I think we realized terminology was introduced at the ICTY much later on. And I think we realized that terminology needed to come in earlier. First of all, they would all object, all the terminologists would object to you using the word glossary. Wrong term, not terminological enough. Glossary is kind of light-hearted thing. No. This is every term has to be verified. Every term has to be, so it was a very heavy work. So I would say that looking at how. First of all, we didn't know which cases we would have, so we didn't know which systems we could only assume what systems we would deal with, and in fact, what we knew and what was done in the first years by an excellent terminology unit was to create bulletins, terminology bulletins, so that we would have, and one of those that I really, really liked, and I think I still have a copy somewhere, that was the courtroom terminology. And that was the only one I can think of, I think in the world, I'm sure, which has so many languages that have never been used before. So we have courtroom terminology in Swahili, in Acholi, but each one, it looks wonderful. You look at it on the page, you say, oh my God, this is amazing. But in fact, each language had to be set up. So just to give you an example, for Acholi, you had to have an expert panel. So you have to bring, so I don't know Acholi. I can only say one word in Acholi, and that's apoyo, thank you. But imagine, so we are going to set up something. We really have to bring people who know what's what. So we brought two translators, interpreters. We were able to find who were local in so Acholi English. Then we had a translator who was a solicitor, so she was a lawyer. From Uganda. Then we found one magistrate from Gulu in Uganda, northern Uganda, who was able to travel. Now, for some languages like Acholi, it is not the young people who know very much their language. So we had to seek out the elders precisely to find. So this man was a magistrate. There was this panel of 4, plus we added our terminologist, who was then had to. So if she didn't know, she obviously didn't know Acholi, but we had to understand, how do you say registrar? How do you say prosecutor? How do you say charges and so on? So sorry, this is a whole other lecture. But this was really, so we imagine we had to do this for every language, including Georgian. A couple of years ago, we did it for Georgian. So that was pretty amazing. And of course, all of them have to have their Rome Statute translated into that language. And I remember that Georgia had already translated into Georgian, but we were not happy with the translation, or rather our expert panel wasn't happy. So that created another headache. How do we tell the Georgians, and so on and so on. So that was, yes. Sorry, it was a long answer.
Thanks, Alex. Yeah. Sandra, over to you now.
Thanks, Alex, for that excellent presentation and so informative. There are many questions here. In connection with your last explanation about the terminology bulletins, are they available to the public? Can we access them, or are they closed?
Oh, I don't know. I think they're probably, I think some of them are on, well, we had a very little presence on the web. We had, I don't know what the situation is now, very little presence on the website. So I don't know, and this was kind of slightly deliberate.
Okay.
Alex,
yes,
to have
Alex,
them.
I would say that interpreters have zero presence on the ICC website, which is shocking.
Yeah, but it would be excellent to take advantage of all that hard work for other interpreters around the world. One question I had was, when you said that there were complaints after people were comparing the English and the French on the screen, how were those complaints expressed, and how were the interpreters able to defend themselves?
The complaints, the best complaints are those that come straight away. So the best complaints is if a counsel says, I would like to refer to line 47 in the English transcript. This is not what I said. In French, I said this, and this was translated. And then it can be corrected on the record. And then it can be clarified. However, the complaint, the normal procedure was to actually send a transcript correction. But of course, there were also, and I'm trying to be very neutral and objective here, I'm no longer working there, is that some counsel were a little sneaky, because they thought if they could only show that there's incompetent interpreters or deliberately misleading interpreters, which is nonsense. Of course, we want to do our work well. So they would write a motion that this whole transcript of 3 months of trial has to be reviewed, which is of course nonsense. And of course, the judges would say, well, you identify which are the parts. So this is how I think it came to be. So we ended up working on these spreadsheets with the original, the translation, and then we were able to see if there was really a difference. Occasionally, we would see that they were using the unedited version of the transcript, which of course created another. No, it's not the working version that you want available during the hearing, but the one available 24 hours later. So, I think it's an ongoing battle. I haven't checked with my former colleagues. It's a big issue, but it's an issue also because they're fighting for their client. I mean, for either the prosecutors are fighting for their case. So it's a love and war, I would say.
Yes. There is a question here about the meaning of shadowing in the context of training interpreters, rather than, I'm assuming it's not shadowing as we do for training conference interpreters. So can you explain how that works?
Yes. So first I would go into the book. So this is if you're not an interpreter, it's normally you cannot actually just go into the booth. You have to be cleared to go into the booth, in a sense that, of course, it could be a protected witness and so on. And so once you enter, you're kind of cleared and you're a trainee. You go in, and then the first few weeks you would be sitting at the back, so not near the microphone, and you would be taking notes, listening. So you are looking at how the interpreter, how they're working, how they're helping each other. Very important. Interpreters have to work together. how they're showing each other, oh, you're here, or writing down. So it's really looking at not just how the work is done, but also the attitude. One would hope helpful. Not all interpreters are helpful to each other, but that's another lecture.
Yes. So shadowing the interpreters rather than shadowing the message.
Yes.
Yeah. So there are a few questions here about the length of the sessions and whether there were 2 interpreters in the booth.
There were 2 or 3. In the ICC, it is usual that there are 3. I would argue you would always have to have 2 plus 1 in reserve. Also because imagine somebody falls ill. If you have 2, what are you going to do? Cancel the session? Because that's what you're going to have to do. You can't have 1 interpreter in the booth. So I always thought 3 was a safe number. You don't necessarily have to have the 3rd one there the whole time, but you have to have, because the sessions are, I think, depending, I think it was to do with the tapes that were being used for recording the sessions. So normally people would be working normally half an hour, as is normal. But the sessions were about 2 hours and then a half an hour break and then another hour before the lunch break. So it really depended on whether there were trials both in the morning and in the afternoon, the ICTY and other. But when we look at the scrutiny and the pressure that the interpreters are under, the fact that they're the legal status of the transcript, and I do know that some courts and tribunals, for instance, the Special Tribunal for Lebanon, Ludmila, correct me if I'm wrong, I think they have a statement on their website saying that the transcript is, I don't know, I think that there was a discussion. But certainly the European Parliament, they have a disclaimer on their website. You can listen to the interpretation. The interpretation is not it's not what's valid, although even, it's not a trial. So I think if things should be done again, I would say go back to 1994 and do not have a legal status for the transcript. Because I think it kills the actual courtroom users listening to interpretation. That one, and of course, transcript is supposed to be help. It's not supposed to be the be-all and end-all. Technology is there, so it has to be used. If it has to be used, you know how much it costs to get court reporters, it's all huge costs. So, well, we better make sure that it's used, and it's going to be used. It's going to be used to the full. So. That's my view.
Yeah, that's right. Someone's asking about the psychological support, which you said wasn't done until later. Can you tell us a little bit about that and how it was done?
Yeah. I don't know why. Well, I don't know why it wasn't, but I guess a lot of things we were discovering as we were going along at the ICTY, and I think we got the first staff counselor. This isn't just for interpreters, but all investigators, analysts, everybody. And I think the first staff psychologist came much later. I can't remember when, but it was at least 4 or 5 years. And before then, I think a lot of us sought psychological support just because we needed, all of us had nightmares when we started working there, because you're dealing with the subject matter. This is not, if we're looking at the news, we could say, all right, I'm not going to read this because it's upsetting, but if it's your work, well, you can't choose. And I think I do recall one very good friend of mine who was also aware of the fact. She came from Bosnia. She was already traumatized. She started working, is extremely devoted, and went to seek psychological support in The Hague. Now in The Hague, the Netherlands, it's a very nice, peaceful country. The actual psychologist was completely unable to deal with her trying to unburden herself. So she ended up comforting him So I actually, thankfully, she had a sense of humor to actually laugh about it. But we all realized, hang on a minute, we need something else. Because what happens, and in fact, the UN also came to its realization much later. And now, later on, all the UN staff were given. There's a little card that you can carry on how to recognize secondary trauma. Because the ICC is not part of the UN, but it has certain aspects of the UN system. And of course, for instance, we were all the security screening, all of the security certificates went through the UN, because otherwise it would have been terrible for the ICC to have to set up this. And I remember we went through this, and there was this little card that we were given, and it said, so if you feel despair, if you're drinking more, if you're engaging in risky behavior, so you can actually recognize the symptoms of secondary trauma, because it's to do with, unfortunately, exactly what the interpreter that I gave you the quotation from said, numbing the senses. You know, it's about, I don't want to feel, I don't want to remember this, but it's very important to face it and to say, you know what, this is terrible. And I think debriefings really help when interpreters can get together. And this is what we did introduce very early on at the ICC. I'm not saying it stops secondary trauma, but it well, at least it makes you aware. And in fact, we also did a training for field interpreters, which is obviously still running, I'm sure. And one of the things that the excellent field interpretation unit did there was to say, we are going to call it self-care. And self-care, so it's not prevention of secondary trauma, and self-care. What is self-care? Self-care is learning to breathe, learning to take stock, to be detached, to realize when you need help, and so on. So self-care is something that I recommend when I'm talking to my students in Belgrade. Of course, all interpreters need to exercise self-care, to breathe, look after their vocal cords, and so on. So, yes.
Yes, thanks. I mean, that's excellent advice for interpreters here as well in Australia, in relation to court interpreting as well. There are a few questions about preparation. What type of preparation? How long it would take on a daily basis? What documents, etc.
I think it depended on the subject matter. It depended on the interpreter. It depended on the. I was 30 when I started working at the tribunal, and I felt I felt comfortable with the languages, except what I described as my inability to interpret simultaneously into BCS. But I was extremely worried about the subject matter. So I would prepare like a complete. Somebody who needed to excel at a test. I like tests, so I'm gonna study for the test. Some more experienced interpreters didn't prepare that much. To be honest, I can't say that any of them suffered from it, in that sense that they didn't know something, because they had enough experience to always be able to. But that's to do with experience as well. Some of the preparation sometimes would take a whole day, and we did have the working conditions were very good, in the sense that we had, I'm trying to remember, between 24 and 28 hours a week work. And the rest of the time you were supposed to be on call or preparing. And I did that. And I remember the longest I've ever prepared was for a ballistics testimony of an expert, because it was to do with artillery and mortar, and there's a difference, and I'm terrible at physics, and all of everything that he testified about was all about physics. And the thing is, if you're supposed to interpret something that is extremely, where did the artillery fire come from? And it's all to do with angles. And unless you can visualize it, it's extremely difficult to interpret it, but then to ask questions. And I remember that at one point, there was a French-speaking judge asking a question about it. And I had prepared so well, but of course, like in a test, the more you prepare, sometimes you can't actually hear something that's quite simple. So he was asking a slightly complicated question, and I was interpreting it in the worst possible way, making all of the wrong pauses because I was trying to get to see what he was getting at. And at one point, I understood his question. And I actually said into the microphone, "Oh, yes," because I was so happy that I had understood. So everybody just turned around. What's happening? Why is the interpreter happy? And I just continued and asked the question. So sometimes, that preparation can be from just reading a witness statement. But as I told you, what if they change and they're going to discuss why the witness shouldn't testify? So yes, the more nervous you are, I found the more preparation you needed. So yeah.
Yes.
If I can jump in there, Alex, what's important to highlight is that the interpreters at ICTY and ICC were on contract. So they were employed full time. They were considered to be as well the equivalent of the officers of the court. They have had access to just about everything, all the documents, and they are given time to prepare. So that's very different from interpreting by freelance or casual interpreters.
Yeah. Well, I think that brings us to the end, and also to repeat the many thank yous for such a wonderful presentation from many of the participants. So thank you again from me, Alex, and over to you, Ludmila.
Alex, also thank you for highlighting the complexity of interpreting in war crimes trials. There are lots of very important lessons that domestic courts can learn from international courts, but it doesn't mean that everything is perfect in international courts either. So thank you very much indeed. And to our audience, thank you also for being with us tonight. There will be another seminar in about a month's time on the 17th of May, and it'll be dedicated to interpreting in the coronial inquest of Theo Hayes, a Belgian backpacker who disappeared in Byron Bay, and it will be presented by our tutor, our graduate and French practicing interpreter, Camille Lapierre. So you will be welcome. Thank you very much again to Alex and to everyone, and to you, Sandra, for moderating. Yeah, bye-bye.